Bueno, vamos a escuchar a la señora Laura Neuman, directora asociada del programa americano del proyecto de acceso a la información del Centro Carter. Sí, yes.
Could the president of the committee nod if she can hear me?
Yes. Sí, sí. No, no sé si...
There's a delay in the webcast. That's a problem.
I'm sorry, I can't tell if you can hear me. Could somebody just give a thumbs up if you
¿Por
can
qué
hear
no
me?
escribís diciéndole?
The issue. I know we're running pretty far behind, so I'm going to just take a few minutes to talk a bit about what some of the next steps might look like and provide perhaps a few considerations for the member states regarding moving forward in the OAS. Again, you've heard about the Claude Reyes case, which is really the most important decision that we've had around the right to information around the world. Particularly because it sets out not only that this is a fundamental human right, but also some clear standards for the states and what they must do, some serious obligations. In addition, we've most recently had the recent principles of the Inter-American Juridical Committee, which is some 10 standards for legislation. We've had the successive General Assembly resolutions. And now there's a question about how to move forward. And again, this morning I'd like to mention a few of the potential next steps, some benefits and perhaps drawbacks to each of those, and then a few recommendations for future action. One of the ideas that's been emerging is this the potential for an Inter-American Convention for the right to access to information. And while a convention can serve to harmonize and to incentivize, it can also potentially limit the advancements that we've seen. So with your permission this morning, I'd like to talk a few of the benefits of a convention, but also some potential drawbacks and some additional considerations. So in general, and these are things we all know, but what are the benefits of a convention and right now about a convention for the right to information? One of the clear benefits is that a convention serves as a great advocacy tool, both for states, people, champions within the states who want to move forward their right to information, as well as civil society. And it provides a commitment from the states that can be used as a leverage to move forward good legislation. It also helps to establish regional norms and can then make those norms part of a domestic system. A convention provides the collective expression with regards to the subject of a treaty. So what conduct is acceptable and what is unacceptable? Or in this case, what must be in an access to information law, how must it be implemented, and particularly how should it be enforced? Conventions are binding on the signatories, including any inter-American decision then would likewise with relation to the convention, would likewise be binding on the states. It can provide, perhaps most importantly, some supervision, monitoring, and encourage compliance. And it creates incentives for countries to engage in favorable expressions and behavior. Unfortunately, although those are all the potential benefits, there are also a number of potential detriments or limitations on the use of a convention. And I would say that the most important two concerns would be, one, the amount of time that it takes to work on a convention. A lot of energy, as you all know, and effort can go into the drafting of a convention, and that's energy that in some ways could be used to really advance the states. So what we've seen in other contexts, and other, both around access to information and also other contexts for conventions, is that states tend to slow down as they're waiting for the convention to actually be drafted and then applied. It also sometimes leads to this phenomena of the lowest common denominator. So where the states might be more advanced, once a convention comes in, for example, on legislation, they may actually have to lower or decrease what they've been doing. So rather than expanding, it can serve to decrease. And a perfect example, actually, if I may, is China, where I just came back from. And as many of you may know, most recently in May of 2008, the Chinese started to implement an open government information regulation, which is amazing given that it's China. Before the national regulation, there had been a number of provinces, huge areas that had already had their regulations, like Shanghai and Guangzhou and a few other provinces. Those regulations actually were more expansive than the national regulation. So when the national came into effect, those areas that had been more liberal in their provision of information had to actually decrease the amount of information they were giving out. We can see the same kind of phenomena with conventions if they do lead towards the lowest common denominator. And another example of this is what just happened at the Council of Europe, which recently adopted a convention on access to official documents. It's the first convention of its kind, and it's had a host of criticism. The criticism has actually gone on two routes. One was the process used to draft and approve the Council of Europe's convention, and the second criticism, so partially on its adoption, how it was adopted, and then also its content. It's weaker than many of the member states' national legislation, so it's putting in question what's going to happen with the national states. And according to a number of critics, it did not use a very inclusive process. So where civil society sent a whole series of recommendations, most of those were ignored. And the process as well was according to civil society advocates and some states, was not transparent. So the debates that went on regarding the provisions and the recommendations that and inputs from civil society was not done in a transparent manner. This was just approved in the last few weeks, and there's been, as I say, a host of criticism launched against the Council of Europe for this convention, which is, I'm sure, not at all what they had hoped for in moving forward towards a convention on this fundamental human right. Some other potential limitations or detriments to a convention, again, it's not necessarily the most useful for advancing the right to information, and it's often unenforceable, which ultimately diminishes the value of the right to information. It can be, as well as I said earlier, distraction from the real work of establishing the right to information, and doesn't necessarily address the biggest problem that we're facing with access to information in the region, which is its implementation and enforcement. I'm certain throughout this conversation you've been hearing about the issues facing the states. I know the states have been talking about the advances that they've made, and while our region now counts on maybe 14 or 15 countries with national legislation, and even more with executive orders or municipal rights, municipal legislation. I think we can all agree that there's still a struggle, still a challenge to implement fully and effectively these laws and to assure their enforcement. And a convention, unfortunately, often doesn't address those real issues of implementation and enforcement. So if we move away from a convention or consider other mechanisms in the interim, what might those be? And I'd like to suggest 4 potential other mechanisms if the Assembly determines not to move to a convention at this point. The first would be, I would suggest, an expert working group with the states to come up with a standards document, taking what the Inter-American Juridical Committee has done with their 10 principles and really putting some more details to that, and including issues around implementation, detail out issues of implementation and enforcement. A second potential could be taking the Summit Declaration of Nuevo León that calls for access to information and adding a plan of action to that. So rather than a convention, really focusing on how to give meaning to the Summit Declaration. A third potential could be an inter-American program. Like with the convention, there's some positives and negatives to that. If done well, it certainly can guide the states. It can also have a plan of action. It would be critical that it includes, again, some oversight mechanism, perhaps much like the Convention Against Corruption, but put that into an inter-American program. And it really needs to have, as always, some forms of funding. So not only for the states, but also funding requirements, mandates for the OAS so that they can do the work necessary to ensure the application of the program. And the fourth potential other mechanism to consider would be some voluntary follow-up mechanism, again, mirroring what you have in the Convention Against Corruption, making it voluntary at this point for the states, but providing some really good platforms and lessons learned on how to do oversight, how to do monitoring, and how to ensure enforcement. What that mechanism could look like is states could fill out questionnaires and then come before an expert group of states and present where they've gotten on the advancement of the right. So do they have a law? What have they done to implement it? How is their enforcement going? And then there could be a portion of time for civil society from that state to also comment on how the state is going. And a report card of sorts, a scorecard of sorts could be generated from that. Not comparing state to state. Every state is going to be different, dealing with its own specific issues, but really a report card of how that particular state and of their particular law. The Carter Center recently held a conference, as many of you may know, which brought together 125 representatives from 40 countries. At the conclusion of the conference, the participants issued a declaration and plan of action for the advancement of the right of access to information. This document captured principles and findings of the working groups, including a working group that looked at the necessity for regional or international norms and conventions. And I just wanted to point out that at our conference there was a great debate regarding next steps, whether there should be some kind of international convention from the United Nations or regional conventions. And it was very difficult to reach a consensus. And much of that was in light of what was happening at the Council of Europe. I would certainly encourage the states to learn from the experience of the Council of Europe, and should we in the Americas move forward towards an inter-American convention on the right to information, I would hope that it would be strong enough to really set the standard so that others could, in their regions, push towards what we are accomplishing. Based on the various experiences in the conventions and findings at the Atlanta conference, of which, with your permission, I would love to send to each of the states, as well as my comments in writing, since I recognize how fast I'm going, I'd like to give a few following final recommendations. Certainly, regardless of what instrument is chosen, whether the states determine to move forward towards a convention or explore some other more voluntary mechanisms or an inter-American program, I believe that the OAS should ensure that the civil society is meaningfully consulted and is done so in a transparent way and a timely way, so that feedback and input from civil society is at every stage of the drafting and approval of whatever mechanism is decided upon. There should also be very clear standards set for the states to follow, and that these should meet the emerging international norms and reach for the highest bar rather than the lowest floor. There must be clear oversight and enforcement mechanisms included as a core part of the instrument. Otherwise, we'll see exactly what other conventions have failed to do, which is encourage, again, the full and effective implementation of these instruments. There should be sufficient funding provided for the OAS departments to serve their clear role of supporting the member states and overseeing and providing that mechanism for states to come and report back. And also, and perhaps this is something that hasn't been discussed already, whatever mechanism is included should not focus solely on the states. There are other actors involved here, including the OAS itself. And as you may have heard, the OAS is, I believe, the only regional organization, including all the international financial institutions and all the regional development banks, as well as the African Union and others, who does not have an internal policy for disclosure. And I would encourage whatever instrument that is decided upon by the member states to include not only mandates and requirements for the states, but also for the OAS itself to ensure transparency in their decision-making processes, and that all citizens of our region can benefit from the right to information at home and also through their regional organizations. So with that, I think I should conclude. I know I've gone a few minutes over, and I very much appreciate the opportunity to talk through a few of the next steps. Again, I'm going to put all of my comments into writing, and I will ask my colleagues at the Commission for Juridical and Political Affairs, or the Department of Legal, International Legal Department, to please send those to all of you. And with that, I don't know if there's time for comments or questions, but unfortunately, there's no time for, according to my colleague Carrie Mackey here, there's no time for questions or comments. So I will thank you very much for your time and look forward to continuing this discussion and debate with all of you. Thank you.
Bueno, le agradecemos mucho a la señora Laura Neuman del Centro Carter y también el que pueda proporcionarnos su intervención por escrito.